Welcome back to the deep dive. Our whole mission here is to take these just overwhelming stacks of documents, the legal filings, the research notes, the court dockets, and really just distill them down into a clear narrative. We want to give you that shortcut to being truly well-informed.
And today we are really going deep. We're looking at a legal conflict that, honestly, it reads less like a case file and more like a geopolitical thriller.
That's a good way to put it. A thriller thought entirely within this procedural maze of the U.S. court system.
That's absolutely right. So for you, the listener, we are charting a war that's being fought on multiple fronts. We're talking state courts, federal trial courts, federal appellate courts. Even the Department of Justice gets pulled into this.
And it all seems to stem from one thing.
One thing. The entire conflict, which spans from about mid-2025 all the way into January 2026, is allegedly rooted in a global whistleblower case. We are dissecting the claims filed by one individual, Reynaldo J. Aguirre Marcano.
And he's representing himself. See that?
Exactly, pro se. And he's alleging a systemic, deliberate, multi-court conspiracy. One designed, in his words, to obstruct justice and ensure his silence.
The documents we have here they're just extraordinary. We've gone through petitions for writs of mandamus, and these were filed with both the Texas Supreme Court and the Fifth Circuit Court of Appeals. We have emergency stay requests, and even a formal criminal complaint.
And his argument ties it all together. Marcano argues that every single procedural block he hits is part of a deliberate effort, a procedural blockade, he calls it.
A blockade with a very specific goal.
To facilitate his unconstitutional imprisonment, all based on an underlying state court matter that he claims is completely fraudulent.
And the details here, some of these claims just push the boundaries of what you expect in a legal conflict.
They really do. We're dealing with admissions captured in certified transcripts that a psychiatric evaluation was allegedly used as a weapon, not a real medical concern.
A weapon?
Yes. We also have documentation showing that a minor child is facing, and this is a, quote, imminent indigency because of these financial sanctions. And then there are claims that, frankly, they escalate outside the courtroom entirely.
Like what?
Including state actors allegedly manipulating local traffic lights to entrap him.
Okay, so we have these high-stakes claims. We have a countdown to potential imprisonment and a legal strategy that is both incredibly complex and just unbelievably aggressive.
So this deep dive is about understanding not just the claims themselves, but the mechanics of how the court system itself can potentially become weaponized.
Exactly. Okay, let's unpack this and start following Marcano's timeline. So let's start at the very beginning. The alleged root of this entire conflict. The motive. Marcano's central thesis, his whole argument, is that this aggressive legal campaign against him, the sanctions, the stripping of parental rights, the threats of contempt, it's all just pure retaliation. Retaliation intended to, and I'm quoting from his filings, silence, discredit, and ultimately imprison him. And this is all for activities that extend way beyond a simple case in Texas.
This is the linchpin. This is the one detail that transforms what looks like a state-level domestic dispute into, at least according to Marcano, a federal civil rights and potential national security matter.
So what's the core activity? What is he doing that would provoke this kind of response?
His work as a federal whistleblower. He has filed, and he says he continues to file, formal disclosures with the Internal Revenue Service, the IRS, under their whistleblower statute.
And these disclosures are about what?
He alleges massive international tax noncompliance, and it involves powerful individuals and foreign entities.
So his legal argument, then, is that the state court in Texas is being used by his opponents as a tool, an instrument of federal retaliation.
Precisely. They're essentially trying to impose a prior restraint, to gag him and stop his federally protected disclosures to the IRS.
And where is he getting this information? The source of the data must be pretty sensitive to trigger this kind of alleged reaction.
It makes the claim truly high stakes. Marcano asserts in his filings that he acquired a large database leaked from the Venezuelan intelligence services.
The Venezuelan intelligence services?
Yes. He alleges this data contains comprehensive information on geopolitical and financial networks. Networks connected to both foreign governmental and intelligence operations. So, this isn't just about some domestic tax evasion. He's trying to connect alleged financial crimes to international political power structures.
And this isn't some secret project he's working on in the background. The documents show he's actually being very open about it. He's leveraging it in his legal defense.
Oh, absolutely. He treats his work as a public geopolitical research project. He's publishing it in a series of books and through a website, XisList.org.
Can you give us an example?
Yeah, to give you an idea of the scope of these claims, he cites one book title in his own filings. It's called Global Strategic Geo-Index, Alaska, Coordinates of Military and Balloon Guiding Significance Addresses of Importance for Chinese Communist Party and PSUV Operations.
Oh.
And he notes that he compiled it. So he is explicitly linking his research to the activities of the Chinese Communist Party and Venezuela's ruling party of the PSUV. So when he says these legal attacks are retaliation, he's anchoring it to this kind of very sensitive international public-facing work.
Okay, so that sets the motive, a very big motive. Now let's map out the battleground. If the motive is federal retaliation, the action is all happening down in the Texas state courts.
That's right. The specific case is the divorce. In the matter of the marriage of Gloria Espina and Reynaldo J. Aguirre Marcano, it's in the 387th District Court, Fort Bend County, and it's presided over by Judge Oscar Telfair III.
And there seems to be a key moment when this all boils over.
The documents point to a dramatic escalation in October of 2025. Marcano filed a motion to recuse Judge Telfair.
Which is a huge step. You're basically arguing the judge is biased or can't hear the case fairly.
A very significant step. Marcano claims that immediately after he tried to get the judge recused, the opposing attorneys G. Troy Pickett and the Adams Law Firm, they allegedly procured what Marcano calls a backdated void order.
Okay, void order. You mentioned that before. When Marcano uses that term, he's not just saying it was an incorrect ruling that he wants to appeal, is he?
No, not at all. This is a crucial legal distinction. In legal terms, a void order is one that a court fundamentally lacked the jurisdiction or the authority to issue in the first place. Or, and this is key to his argument, it's one procured through fraud so severe that the order is legally worthless.
So it's void ab initio, from the beginning.
Exactly. And that's critical because if you can prove the order is void, then all subsequent actions that are based on that order, they're also void. His entire defense really rests on proving this foundational illegality.
And what did this specific, allegedly void order do to him? What was the immediate, painful consequence?
According to his filings, it unconstitutionally stripped him of his parental rights, and at the same time, it imposed these significant punitive financial sanctions.
So it hits him in two of the most critical areas possible: his child and his money.
Right. And this void order instantly becomes the weapon he alleges they're using to coerce him into silence.
And this brings us right up to the deadline he's currently fighting against. By the time we get to January 2026, the state system is getting ready for what he sees as the culmination of this whole scheme.
That's the ticking clock in all of these filings. A hearing was scheduled for January 22, 2026, and it was set to happen right back in front of Judge Telfair.
The same judge he tried to recuse.
The very same one. Marcano's filings, especially the ones asking for an emergency stay from the Fifth Circuit, they state unequivocally that the whole purpose of this hearing is to enforce the void sanctions order.
And the outcome he fears.
His unconstitutional imprisonment. Contempt proceedings. He'd be found in contempt for failing to follow an order that he claims is legally void.
So he sees a straight line. The whistleblowing leads to retaliation, which leads to this allegedly fraudulent void order, which leads to financial sanctions, and the final step is imminent imprisonment, which must have led him to ask, why didn't the Texas judiciary do anything to stop this?
He argues that the failure of the Texas judiciary to intervene is actually evidence of the systemic nature of this blockade. At the trial court level, in the 387th District Court, he claims Judge Telfair simply refused to rule on his repeated motions to vacate the void order for months.
If a judge just refuses to rule on a motion like that, what's the strategic effect?
It creates paralysis, but it maintains the opponent's advantage. I mean, think about it. If Judge Telfair had ruled against him, Marcano would have had a final appealable order. He could have taken that to a higher court.
But by just not ruling.
By not ruling, the judge allows the status quo to persist. The punitive sanctions stay in effect, the restricted parental rights remain, and Marcano can't appeal judicial inaction. It allows that void order to just continue operating as leverage against him. So
he then sought the extraordinary relief of mandamus from the Texas Supreme Court. SCOTX, case number 251055. How did that play out?
According to his filings, he met with similar inaction at the highest level of the state system. Marcano claims SCOTX took no action for over 40 days.
And this wasn't just some procedural request. He was arguing there were real-world consequences to this delay.
That's what's so critical. Marcano filed supplements showing that his minor child was facing imminent indigency as a direct result of the financial constraints imposed by this void order.
So a child's welfare is on the line.
And for the relator, for Marcano, the failure of the Supreme Court to act swiftly when a child's welfare is allegedly threatened by a challenged order. Well, that demonstrates the pervasive nature of the system's resistance to his claims.
So given that the state courts, from the trial level all the way up to the Supreme Court, allegedly refused to break this stalemate, he was effectively forced to go federal, wasn't he?
He had no other choice. He's now seeking relief from the state system's alleged failure through the federal civil rights structure.
So he's facing this January 22nd deadline. He's getting this systemic non-response in Texas. And so he files his federal lawsuits in the Southern District of Texas, the SCOTX. He filed 2 separate actions to stop the harassment. One is called the Musk case, which is before Judge George C. Hanks, Jr., and the other is the ICO case before Judge David Hittner. Why 2 different lawsuits?
Well, filing 2 suits is a strategic choice. It's likely aimed at maximizing the chances that at least one jurisdiction and one judge will be compelled to act. And it lets him segment these very complex claims.
So what's the difference between the 2?
The RICO case, that's the Racketeer Influenced and Corrupt Organizations Act, that's usually reserved for claims of an organized criminal enterprise. It's the very high standard. In Marcano's view, it applies to this multi-jurisdictional fraud scheme he's alleging.
Okay, and the other one, the Musk case.
That one seems to focus more squarely on the civil rights violations under 42 U.S.C. Section 1983. So claims that state actors, like the judge and others, deprived him of his constitutional rights under the color of law.
So he sought to bypass the state obstruction, only to immediately run into a different but equally paralyzing wall in the federal system. What was the central fundamental problem that stopped both of these cases cold?
It was a basic administrative failure, or, as Marcano alleges, a deliberate refusal. Neither case could advance because the clerk of the court allegedly failed to issue the required summonses.
And a summons is?
It's the single sheet of paper, signed by the clerk, that officially notifies a defendant they are being sued. Without it, you can't serve the defendants. And service is a legal prerequisite under Federal Rule of Civil Procedure 4. It's step 1.
So let's slow down and define this concept for our listeners. Marcano argues the issuance of summonses is a clear, non-discretionary process and a ministerial duty. What does that term, ministerial duty, actually mean in a courthouse?
That's a crucial legal term here. A ministerial duty means the action is automatic. It requires zero judgment or discretion from the court official. It is non-negotiable. If you file a valid complaint and you pay the fee, the clerk must issue the summons.
Can you give us an analogy?
Sure. Think of it like this. If you go to the post office and you pay for a stamp, the clerk's duty to give you that stamp is ministerial. If they refuse to give you the stamp, and then later you get fined for not mailing your letter on time, the fault lies with the system's refusal to perform its basic necessary administrative function.
So Marcano is claiming the federal court clerks are essentially refusing to hand out the stamps.
That's exactly his argument. And this procedural trap means that if the court refuses to perform this basic duty, the plaintiff is then held responsible for the subsequent failure to serve the lawsuit, right?
Exactly. It's a catch-22. The system traps the plaintiff. Rule 4 says you have to serve the defendants, but the court is preventing the very means of service.
And Marcano argues that this refusal constitutes an abdication of judicial function. It transforms a simple administrative rule into a powerful tool for obstruction.
Let's look at Judge Hittner's actions in the RICO case, because Marcano describes this as the most dramatic example. He files an emergency motion on December 10th, 2025, basically begging for these summonses to be issued. What was Judge Hittner's response the very next day?
Judge Hittner's response was, according to the documents, extreme. On December 11, 2025, he issued an order that not only denied Marcano's request to compel the issuance of summonses, but he took the extraordinary step of striking Marcano's entire second amended complaint from the record, specifically document number 27.
Striking a complaint entirely rather than just dismissing it. That sounds like a very technical maneuver.
Yeah.
But it must have huge practical implications. What's the difference there, and why did Marcano seize on this?
This is where the legal strategy gets fascinatingly aggressive. See, when a judge dismisses a case, they usually issue a final appealable order. That allows the plaintiff to immediately go to the Fifth Circuit and argue the dismissal was wrong.
Yeah.
However, when a judge strikes a document, which means removing it from the court record entirely, It makes the document and the jurisdictional basis it contained basically invisible for the purposes of an immediate appellate review.
So by striking document 27, the underlying claims, the constitutional and Article O allegations that gave the federal court jurisdiction in the first place, are just wiped from the official record. And that makes it harder to argue on appeal that the judge wrongly handled a case with serious federal claims.
Precisely. Marcano argues this was a deliberate action. He claims Judge Hittner thereby concealed the basis for the federal court's jurisdiction from appellate review. It ensures that any immediate challenge would have to focus only on the refusal to issue summonses, not on the potential merit of the underlying whistleblowing retaliation claims.
And meanwhile, this same procedural chokehold was happening in the other case, the Musk case, before Judge Hanks.
That's right. The refusal to issue summonses just persisted for months in the Hanks case. And in that instance, the procedural consequence was exactly what Marcano feared. A magistrate judge issued a recommendation on December 17, 2025.
Recommending what?
Recommending the case be dismissed without prejudice for failure to serve. Marcano highlights that this failure to serve was made inevitable by the court's own inaction. The court is essentially penalizing him for a failure that the court itself manufactured.
So Marcano is completely trapped. He has federal claims that could potentially stop the state court proceedings, but the federal courts are procedurally preventing him from even notifying the defendants. This ensures his cases remain dormant while the state court is moving to jail him on January 22nd.
It creates the ultimate legal impasse. He has nowhere left to go but up, which is exactly why he filed the petition for writ of mandamus in the federal appellate court, the Fifth Circuit, on January 8, 2026. This petition targets both Judge Hittner and Judge Hanks to try and compel them to perform that basic ministerial duty, issue the summonses.
Now, mandamus is notoriously hard to get. It's not an ordinary appeal. Walk us through the legal standard for mandamus and how Marcano argues he meets this extremely high bar.
You're right. Mandamus is truly the legal last resort. It's reserved for cases where a court's refusal to act is an extraordinary abuse of power. The Supreme Court requires the petitioner to satisfy this really stringent three-part test, which Marcano meticulously addresses in his Fifth Circuit filing.
What are those three prongs?
Okay, first, he has to show he has a clear and indisputable right to relief. His argument there is simple. Rule 4 is clear, and as a litigant, he has the right to have the administrative function of the court performed.
Makes sense. What's the second part?
Second, he has to show the judges have a clear duty to perform the act. Again, issuing summonses is ministerial, it's a clear duty. But the third prong, that's the most critical hurdle. He must show there is no other adequate remedy available.
And this ties back to our discussion of striking versus dismissing a complaint. Why can't he just appeal what the judges did?
Because the courts haven't issued a final order. In federal practice, you can generally only appeal a final judgment that concludes the entire lawsuit. When Judge Hittner struck the complaint, or when Judge Hanks's court simply stalled and recommended dismissal without prejudice, well, those actions didn't conclude the case with a final, appealable decision on the merits.
So because the case is stuck in this indefinite legal limbo due to the refusal to act,
he can't technically appeal the court's inaction. Thus, mandamus becomes his only recourse to force the case to proceed before his liberty is threatened in the state court. The procedural weapon here isn't denial of a claim. It's calculated indefinite delay and non-action.
It's just an incredible level of high-stakes legal combat. He's trying to force the federal appellate system to intervene and compel federal judges to follow the most basic rule of procedure, all while that state court clock is ticking toward his imprisonment on January 22nd. So if that procedural obstruction wasn't enough, Marcano's documents move into far more volatile territory. We're talking about explicit claims of fraud, deception, and coercion, all allegedly used to secure the very order that now threatens his imprisonment. Let's start with the heart of the state court crisis, the alleged multi-court deception involving that backdated order.
This specific set of claims focuses directly on the conduct of the opposing counsel, G. Troy Pickett and the Adams law firm. Marcano describes this as a brazen scheme of making contradictory representations to different courts, just to manipulate the appellate timeline and eliminate his avenue for review.
Okay, walk us through the specific timeline. How did this alleged fraud happen in October and November of 2025?
All right, it begins on October 10th, 2025. Opposing counsel filed something called a notice of entry in the First Court of Appeals, the first COA. This notice essentially suggested that the contested trial court orders, the ones that stripped Marcano of his rights and imposed sanctions, had already been formally signed and entered.
So they're telling the appeals court it's already done.
Exactly. And based on that representation, the first COA dismissed Marcano's prior mandamus action on October 14th, 2025. They ruled the case moot. The court just accepted the premise that the disputed event had already happened, which rendered his request for relief pointless.
So on October 14th, the appellate court washes its hands of the matter because the orders are supposedly already in effect.
Precisely. Now, here is the crucial twist. Weeks later, on November 7th, 2025, G. Troy Pickett filed a motion back in the trial court, the 387th, and he attached copies of those very same orders.
Okay.
These documents, however, were dated as having been signed by the judge on October 15th, 2025.
Wait a minute. So the appellate court dismissed his case as moot on the 14th, based on the assumption the orders were signed, but the signed orders that appeared later were dated the 15th.
A full day after the appellate court had relied on the representation that the orders were already entered to dismiss his appeal.
So the premise they used to get the appellate dismissal was demonstrably false at the time they filed the notice.
That is Marcano's central explosive argument. He asserts that Pickett's November 7th filing, the one containing the October 15th bait stamp, functions as a written confession of fraud. It proves, in his view, that the basis for the appellate dismissal was a falsehood. This is a very, very serious allegation. He's essentially suggesting that attorneys misled two different judicial bodies at the same time to get a specific procedural outcome.
And Marcano links this immediately to federal criminal statutes.
Yes, he does. He argues this scheme was the predicate, the foundation for acts of interstate wire fraud. He states that once the opposing counsel used interstate email systems to communicate these allegedly fraudulently procured orders, which, remember, contained financial obligations and sanctions, they were using channels of interstate commerce to perpetuate a scheme of fraud intended to secure unlawful monetary gains.
And that elevates this from a state court sanction issue
To a federal criminal matter, which is why he filed a parallel criminal complaint with the DOJ.
This alleged fraud provides the necessary context for the next deeply sensitive and alarming claim, the use of a psychiatric evaluation as a coercive weapon. This centers on a failed mediation attempt back in June of 2025.
The documents include a certified translated transcript from a recorded conversation. It involves the real party in interest, or RPI, Gloria Espina, and it happened shortly after that mediation failed.
And what happened in that mediation?
Marcano states his prerequisite for negotiating any settlement was extremely specific. He wanted the RPI to provide a handwritten note affirming she had no reason to think he was mentally incapable of entering into a contract or negotiation. Basically, a note saying he was of sound mind.
Why was that note so important to him?
Because the opposing side had already filed a motion for a compulsory psychiatric evaluation. They were implying his mental health was at issue, and that could potentially complicate his ability to represent himself or enter into legal agreements. Marcano knew that if they gave him that note, it would completely undermine the basis for their mental health motion in court.
And what did the RPI say in the certified transcript about why she didn't provide that note?
The RPI confirmed her lawyer advised her specifically not to provide it. The reason she gave in the transcript was that doing so would invalidate their prior point of view, the claim of his mental instability, and it could potentially make her look like she was just making up lies out of nowhere if the case went to trial.
So that suggests it was a tactical position, not a genuine concern.
That's Marcano's argument, that it was a position they could not afford to contradict, even if it meant sacrificing a chance at a settlement. But the most crucial admission, the one connecting the dots between settlement leverage and the medical procedure, comes at timestamp 0.03.26 in that certified transcript.
And what was that?
That's the stunning admission. The RPI admitted explicitly that if they had reached an agreement in mediation, there would have been no need for Marcano to undergo the psychiatric evaluation.
Wow, that one line just changes the entire nature of the motion for an evaluation. It moves it from a medical safety concern to a coercive legal bargaining chip.
Absolutely. Marcano concludes, using that transcript, that the motion for psychiatric evaluation was never a good faith concern for mental health, but rather a bad faith litigation tactic used as a weapon of coercion to gain leverage.
And leverage to do what?
To force him to accept a settlement that included an unconstitutional gag clause or prior restraint, something that would prevent him from publishing or continuing his IRS whistleblower disclosure work. It's an alleged use of the court's procedural power to enforce political silence.
The urgency of this whole conflict is further highlighted by the condition of the minor child involved. Marcano references a fourth supplement and a letter from opposing counsel G. Troy Pickett, dating December 22, 2025.
Yes, and Marcano introduces Pickett's letter as a direct admission and corroboration that the financial sanctions from that void order have had catastrophic consequences. The letter, he claims, confirms that the minor child is in imminent danger of being made homeless.
Why?
Because the RPI, Gloria Espina, cannot pay rent due to the financial complexities and sanctions of the ongoing litigation.
Using a child's impending homelessness as a data point in a legal fight that's already alarming. How did Pickett propose resolving this crisis in his December 22nd letter?
Well, Pickett's letter offers a path to resolution, but it is deeply conditional. He proposes moving the case into arbitration. He even suggests it would get us out of Judge Telfair's court and resolve the matter much faster.
Which could be seen as a backhanded admission that Judge Telfair's court is the source of the stalemate.
One could certainly interpret it that way.
So what were the specific demands Marcano had to meet to even start that arbitration?
He had to agree to two things immediately. First, he must pay $2,549 per month for rental expenses, including 2 past due payments, to immediately address the child's housing crisis.
And the second thing?
Second, and this is critical, he must accept that the temporary orders, the very orders he claims are void and fraudulently procured, are currently valid. He has to agree to comply with them until an arbitrator changes them.
That second condition is the strategic key, isn't it? He's being asked to sacrifice the core legal premise of his entire multi-court campaign, that the orders are void in exchange for securing immediate housing for his child.
Exactly. If he accepts that the orders are valid, his entire defense collapses. He loses his ability to challenge the underlying structure of the sanctions and the parental rights deprivation. Marcano views this as attempted extortion, using the child's imminent indigency, which was caused in part by the very dispute, as leverage to force him to abandon his legal rights and his whistleblowing claims. This detail just underscores how incredibly high the stakes are in this procedural war.
Now, we have to shift from the highly technical, dense legal maneuvering inside the courthouses to a different but equally critical dimension of Marcano's claims. We're talking about the alleged non-legal, technical, and physical harassment campaigns that are detailed in his filings, specifically in what he calls the KOL Mobile V6 logs.
This is where we move into surveillance, system manipulation, and physical threats.
Right. This material provides the context of genuine fear and, you could say, perceived paranoia that surround his aggressive legal actions. He seems to believe that judicial obstruction and the fraud schemes are just two facets of a much larger coordinated effort to neutralize him.
An effort involving non-legal actors and state surveillance.
Let's start with the specific procedural anomalies on January 9, 2026. This concerns the Texas Supreme Court, SCOTX. Even after filing for mandamus there, he experienced these really strange service failures.
Right, so on January 9th, the SCOTX docket for his case no. 25-1055 indicated a major ruling had been made. His petition for writ of mandamus was denied, and related motions were dismissed as moot.
Right.
But Marcano, who is a registered e-filer, stated he never received electronic service of the order. And crucially, there was no downloadable link to the signed order available on the public docket.
Why does the immediate delivery of the order matter so much in a situation like this?
It dictates his next steps. I mean, if the highest state court denies his relief, he has to know the basis for that denial immediately. He needs that information to either file a motion for reconsideration or, to use that denial as evidence in his federal stay requests. Delaying his access to the signed, formal order critically impedes his ability to take appropriate subsequent action.
And he also notes a crucial document he filed that very same day allegedly failed to appear on the public docket.
Yes, at 7:33 a.m. Central on January 9th, he filed a relator's notice. This was to alert SCOTX to his federal escalation, namely his mandamus and emergency motion for stay filed in the Fifth Circuit, and his criminal complaint filed with the DOJ Public Integrity Section.
So he's officially notifying the Texas courts that he's moving this into federal and criminal spheres.
And he claims this crucial notice was suppressed. It just did not appear on the public docket.
He attributes this lack of electronic service to a history of due process violations, saying e-service is the only reliable method.
He filed supporting documentation with the Fifth Circuit about this. He detailed a history of his official mail being returned as undeliverable or marked as vacant in USPS databases. He's got entries he documented from January 7th and December 22, 2025. He claims adverse parties are actively working to compromise his physical mail address.
And if physical mail is compromised and electronic service is withheld or delayed.
Then due process, the right to timely notice, is fundamentally undermined.
Okay, moving to the purely technical claims. Marcano details e-filing system manipulation, and this targets his opponent's names within the e-filing system itself.
This is a really remarkable claim of procedural sabotage at the most granular level, and it's logged in his KOL Mobile V6 logs. He alleges that opponents modified the last name of William Kyle Adams in the eServe system of Tyler Tech.
Tyler Tech is the big vendor for e-filing across Texas courts, right?
The dominant one. And the modification involved changing the name from William Kyle Adams to William Kyle Adams. They suppressed the space between the middle and last name.
That sounds almost trivial, yet he links it to a specific legal strategy. Why would anyone bother with suppressing a space in a name?
Because proper service, especially in sensitive litigation, relies on the exact legal name being used on official documents. Marcano claims the goal was to allow the opposing counsel at some later date to argue that they were not legally served in future proceedings because the name listed on the electronic notice, William Kyle Adams, did not match the official name, William Kyle Adams.
So it's a calculated, tiny vulnerability designed to invalidate service down the road.
That's his claim. And he ties this to another claim that this same attorney, William Kyle Adams, changed his registration with the state bar, allegedly to distance himself from the Adams law firm that was involved in the earlier alleged multi-court fraud.
Now let's address the claims that really push this case out of the legal realm and into surveillance theater. The non-legal claims of targeted harassment. We have to put these claims into the context of the deep fear Marcano expresses about the high-stakes nature of his whistleblowing.
The KOL Mobile V6 logs, which seem to be Marcano's personal records or communications detailing his perceived security environment, contain these extraordinary claims dated around January 8, 2026. One report he cites alleges he was told by an informant that they're playing with the timing of the traffic lights and intentionally blocking me at intersections.
And the ultimate dark objective of manipulating traffic signals.
He claims the objective is to force him to run over a red light. That would then allow law enforcement to detain him and book him for public endangerment. If he's detained, especially under allegations of reckless behavior, it could seriously undermine his credibility in his ongoing legal battles and, potentially satisfy the opponent's goal of imprisonment just through a different mechanism than contempt.
And his response to this alleged manipulation is a unique personal form of civil disobedience, isn't it?
It's a truly remarkable detail. He states that he responds to this alleged traffic manipulation by driving with extreme caution. He specifically states he drives like I am a judge driving his car. E.g. like Honorable Hittner, I imagine he would. This detail is a profound illustration of his state of mind. He is connecting the highest levels of the judiciary directly to the physical threats he perceives on the street.
Beyond the physical interference, he also documents claims of sophisticated digital and mail surveillance.
Yes, and he notes highly specific details. He mentions a neighbor, John Miko, of 2310 Britain, displaying an alert signal. Most crucially, he details an incident involving the Catwoman of 2310 Britton Ridge. He alleges she placed a downlink sensor next to the trash can, directly on the critical path of the true east of the antenna.
A downlink sensor. What's the implication of placing that there?
Marcano believes this was an attempt to intercept or compromise his satellite internet communications. He suggests this happened because he had briefly connected an old computer they have bugged to his Viasat internet connection.
And this computer was special somehow.
This old computer, he claims, contained the authentication credentials to one of the Google accounts they are dreaming to kill. He claims he had already made all essential information redundant months prior, but he views the physical placement of that sensor on the critical antenna path as definitive evidence of ongoing, highly targeted digital surveillance linked to his opponent's desire to neutralize his communications and his data.
So when we combine everything, the backdated order fraud, the psychiatric evaluation as coercion, the refusal of federal judges to issue summonses, the missing state Supreme Court order, and now the alleged traffic light manipulation and sensor placement, Marcano is fighting a war where the courthouse and the street are equally dangerous zones. The complexity is it's overwhelming.
It paints a picture of a single individual, representing himself, pro se, attempting to navigate a conspiracy that he believes spans state family courts, federal civil rights actions, appellate mandamus, and even what he perceives as a sophisticated, coordinated physical and digital security campaign. all of it rooted in his high-level international whistleblowing. This is why procedural rule application becomes the ultimate battleground.
Let's take a moment to reflect on the nature of this procedural blockade itself, particularly the refusal to issue summonses under Rule 4. Given the massive difficulty of getting a writ of mandamus, why didn't Marcano, facing such powerful resistance, just drop the existing federal complaints and refile them, maybe in a different federal district or under a slightly different title?
That's a great question about strategic choice. Marcano's primary goal isn't just to file a case. It seems to be to establish a legal record documenting the specific constitutional violations by the people who have already acted against him, Judge Telfair, the opposing counsel, and potentially the federal judges who refuse to act.
So if he just refiled elsewhere?
If he drops the cases and refiles elsewhere, he loses the immediate opportunity to challenge the actions of Judges Hittner and Hanks via this Fifth Circuit mandamus petition. Furthermore, if he refiled in a new district, he would risk losing his original filing date, and he would probably have to face that same Rule 4 summons barrier all over again. The mandamus petition is his attempt to legally define the inaction of the SCOTX as an unconstitutional failure, to set a precedent that protects his right to access the court.
And what about the risk for the opposing counsel, G. Troy Pickett, regarding that certified transcript and the psychiatric evaluation admission? I mean, was it a massive risk for the RPI to be so explicit about the evaluation being contingent on the settlement?
In litigation, yes, it's a profound risk, particularly if that transcript is verified and authenticated. Motions for compulsory psychiatric evaluations are supposed to be based on a good faith concern that the litigant's mental state is genuinely in controversy and that good cause exists for the examination.
And this transcript suggests otherwise.
If a certified transcript shows the motion was viewed by the real party in interest as purely a bargaining chip to secure a non-disclosure agreement, a gag clause, it can lead to severe sanctions against the attorney for bad faith litigation conduct. Marcano is strategically using this transcript as proof of an abusive litigation tactic that goes far beyond normal advocacy. It strongly supports his claim that the domestic case is purely a weapon to stop his whistleblowing.
It's clear that every single piece of documentation, from the traffic logs to the certified transcripts, is being marshaled to prove a singular overarching claim, that the legal system itself is being manipulated to enforce political silence.
So, stepping back, the sheer complexity of Marcano's multi-pronged legal strategy, it's really designed to create simultaneous pressure points on every court that has touched his case.
He's everywhere at once.
He is. He is aggressively pursuing relief via mandamus at the state Supreme Court level, the SCOTX. He's got civil rights and RQ actions at the federal trial level, the SDTX. He's seeking mandamus and emergency stay relief at the federal appellate level, the Fifth Circuit. And on top of all that, he submitted a formal criminal complaint to the DOJ Public Integrity Section.
And that complaint alleges what, specifically?
Conspiracy against rights and deprivation of rights under color of law. The federal statutes 18 U.S.C. Section 241 and 242.
The narrative here really confirms that in cases where these high-stakes, politically sensitive claims are involved, the most fundamental technical rules of legal procedure, the ministerial duty to issue summonses under Federal Rule of Civil Procedure 4, they become the true battleground.
And Marcano alleges these rules have been systematically weaponized to construct a comprehensive blockade, preventing the merits of his highly political international whistleblower claims from ever being formally adjudicated in a federal forum.
So if his claims are true, the multi-court fraud about the backdated order, the documented coercion using a psychiatric evaluation as leverage, and the sustained procedural refusal across state and federal systems, what does it all suggest?
It suggests a deliberate and sophisticated mechanism to transform a civil domestic dispute into an effective instrument for political suppression and extortion. The fact that he is facing imminent imprisonment based on these actions just underscores the systemic failure that he is alleging.
Which brings us to our final provocative thought for you, the learner. We've spent this time dissecting how procedural rules, the very rules designed to ensure order and access to justice, can allegedly be turned into instruments of delay and denial.
If a federal whistleblower making claims about international financial crime and the integrity of the U.S. tax system cannot force multiple federal judges to perform the most fundamental, non-discretionary administrative act of issuing procedural summonses, what does that imply about the actual access to the courts for any ordinary citizen?
And that raises an important question. How fragile are our constitutional rights when they are pitted against sustained, coordinated procedural resistance orchestrated across these interlocking state and federal judicial systems? What happens when the system designed to protect your rights becomes the obstacle itself?